the precedent or lines of precedent that would govern any review of federal legislation related to abortion?
Well, I mean, a few lines of precedent might potentially be relevant, whether it's legitimate commerce clause or, spending clause, that law.
So you recognize Dobbs then as the controlling precedent when it comes to life questions. Is that what I'm hearing you to say?
From the Supreme Court, yes.
What's up, patriots? Welcome back to the channel, your home for common sense, constitutional values in an America that sometimes feels like it's upside down. Today, I want to break down a crucial moment in a recent Senate confirmation hearing. We're talking about Senator Josh Hawley, one of the few senators who isn't afraid to stand up for life, liberty, and the true meaning of the Constitution, absolutely grilling a Biden judicial nominee. This is the kind of stuff the mainstream media either twists or ignores, so buckle up. I'm going to react, lay out what really matters, and give you my honest, patriotic take on this exchange. And let me tell you, there's a lot at stake.
Thank you, Mr. Chairman. Ms. Sibelson, welcome. It's great to have you here. Congratulations on your nomination. Let me just pick up on a question that Senator Blumenthal was asking a moment ago about abortion and life issues. What standards should courts apply when reviewing state abortion laws?
What the court held in Dobbs was that the Constitution doesn't say anything about, does not provide a right to abortion. And as a result, Dobbs returned the issue of abortion to the people and the representatives state by state, and said essentially this is not a question for federal judges because it doesn't say it in the Constitution. It's a question for the people in the democratic process. And that is the effect of Dobbs. And as a result, the state democratic process is now the process that has control over that issue.
What about federal legislation affecting abortion?
Federal legislation affecting abortion would be subject to the same, scrutiny as other federal legislation. It has to fall within Congress's enumerated powers, first and foremost.
What's the precedent or lines of precedent that would govern any review of federal legislation related to abortion?
Well, I mean, a few lines of precedent might potentially be relevant. Whether it's legitimate commerce clause or spending clause legislation is probably the first question that comes to mind, depending on how the law is structured. And if not, whether there is some other, affirmative hook in the Constitution that provides Congress with the power to pass that law.
So you recognize Dobbs then as the controlling precedent when it comes to life questions. Is that what I'm hearing you to say?
From the Supreme Court, yes,
yeah,
Senator.
And the Seventh Circuit or anywhere else for that matter, correct?
Absolutely.
I mean, if there's any contrary Seventh Circuit precedent, Dobbs would supersede that.
Absolutely.
And I'm sorry, go ahead.
No, absolutely. And I would faithfully follow Dobbs.
Good. And you regard it as controlling precedent and as settled law?
Yes.
Let me ask you this. How should courts weigh the rights of medical providers who object on conscience grounds to participating in abortions?
The Supreme Court's decision in Hobby Lobby reflected the fact that employers have important religious rights to, resist the government's requirements that they provide certain forms of health care to which they object.
What about doctors?
I'm sorry, Senator. What about doctors?
Yeah, medical providers. I mean, doctors who object to participating in abortion-related procedures.
Well,
how should a court weigh those claims?
I think I should be somewhat circumspect because there is, litigation pending around the country, and so the canons of ethics preclude me from prejudging these questions too much. But I think the basic method of analysis would follow the Supreme Court's approach in Hobby Lobby, but extending it to that context.
What about pro-life sidewalk counseling outside of clinics? Is that core First Amendment speech?
Sidewalks are recognized by the Supreme Court as core, public fora where the rights to free speech are at their zenith, or at their strongest.
And there's no difference. It doesn't matter if it's an abortion clinic or something else you're saying. I mean, regardless, the fact that the sidewalk is a traditional public forum should control the analysis, whatever the facts of the case may be.
Yeah. Generally, Senator, under Supreme Court precedent, content or viewpoint-based discrimination in the context of a traditional public forum is viewed with extreme skepticism.
Very good. Let me ask you about free exercise questions. Should the free exercise clause be given the same strength and weight of other fundamental rights like free speech?
Absolutely. The free exercise clause, I believe, the very first clause in our Bill of Rights, for a reason.
So it is. How should courts evaluate claims of religious liberty when they conflict with generally applicable laws?
The Supreme Court has spoken to that recently in cases like 303 Creative, and some other, Espinoza, Fulton. And what the Supreme Court has established is that even generally applicable laws don't carry with them an exception to the First Amendment's free exercise clause. And so if the application of what looks like a generally applicable law, like let's say a funding restriction, has the effect of discriminating against people for their religious practice, then that can violate the First Amendment.
Does the Trinity Lutheran case have any bearing here, do you think?
Yes, thank you, Senator. The Trinity Lutheran case concerned, if memory serves, funding for those playground grounds. We've all seen them with kids that are made of, recycled tires.
Correct.
And there was a state program to fund playground grounds of recycled tires. And a church playground, applied for funding, and it was denied on the grounds that, we don't provide funding to church organizations. And so what the Supreme Court held in Trinity Lutheran was, no, you can't do that. If you have a general funding program, you can't discriminate against some of your recipients simply because of their religious faith.
And how does that interact with the Smith case?
The Smith case held that general laws of, I think, neutral applicability don't necessarily violate the free exercise clause, and Smith remains a precedent of the Supreme Court that I would follow. But in the last, 12-ish years, the Supreme Court has explained that Smith doesn't mean a state can effectively exempt a religious entity from a state benefit, which is what was happening in cases like Trinity Lutheran.
Yeah, last question, Mr. Chairman. I think you're Mr. Chairman now, right? Yeah, very good. Just one further question on Smith. So in the Trinity Lutheran case and the Hosanna Tabor case, the Supreme Court said, well, Smith actually is about physical acts. It's not about other things. How do you understand that? I'm not asking you to grade the court. I'm not asking you to go beyond what the court said. I'm just trying to figure out how you're a student of the law. You've worked at that court. You've litigated at that court. I'm just trying to figure out how would you as a judge, you're going to have to read these intersecting lines of cases. What does that mean to you? How do you interpret that? That distinguishing of Smith, what do you think that means? How does that cash out?
That's a tough question, Senator. I think the Supreme Court is, struggling with Smith in many of these religion cases. I think, the other thing that it said in City of Fulton against Philadelphia was that Smith didn't apply there because although there was a general policy, it was one that the city was granting exemptions to, sort of left and right. And so there are certainly exceptions to Smith that the court has recognized. But happily, there are enough of these cases that I think as a lower court judge, you can generally find one that's roughly similar to the facts before you. And that's particularly true in the last 12 or 13 years, where these cases have been uniformly protective of religious liberty. So my essential method would be one of analogy and, to see which of these Supreme Court cases is most on all fours with the case before me.
Thank you very much. Thank you.
First, let's talk about the Dobbs decision. Senator Hawley pressed the nominee on whether Dobbs, which overturned Roe versus Wade and finally handed the abortion question back to the states, was controlling precedent. And to the nominee's credit, he said yes. He said he would faithfully follow Dobbs. Now, as a right-wing patriot, this is music to my ears. For 50 years, unelected judges trampled on the rights of the people, made up a so-called right to abortion that's nowhere in our Constitution. Dobbs put the power back where it belongs, in the hands of the people and their elected representatives. That's what our founders intended. Judges should interpret the law, not invent it. But here's the thing. I don't trust that every judge who says, I'll follow Dobbs, actually means it. We've seen too many so-called moderates or nonpartisan nominees get confirmed, then suddenly discover penumbras and emanations in the Constitution that no founding father ever dreamed of. So, words are good, but actions are what matter. The nominee said, and I quote, "The Constitution doesn't say anything about abortion." Well, that's 100% true. For decades, the left tried to twist the 14th Amendment into a blank check for whatever social change they wanted, from abortion to marriage to everything else under the sun. No, the Constitution is not a living, breathing document that means whatever a judge wants it to mean that day. It's a contract. If you want to legalize abortion nationwide, pass a law. Go convince your fellow citizens. That's democracy. That's federalism. That's how it's supposed to work. Senator Hawley also asked how federal abortion laws should be evaluated. The nominee said, basically, any federal law needs to fall within Congress's enumerated powers, like the Commerce Clause or the Spending Clause. Now, as a conservative, I'm always wary when Congress tries to stretch those powers. The Commerce Clause has been abused for decades, but at least this nominee admits Congress can't just do whatever it wants. There are limits. There's a framework. That's what keeps us free. Here's one of the most important parts for me. Senator Hawley asked about medical providers, doctors, nurses who object to abortion on religious or moral grounds. The nominee referenced the Hobby Lobby decision, which said employers don't have to violate their faith to comply with government mandates. Look, this is America. Freedom of conscience is one of our oldest, dearest principles. If you're a doctor and you believe abortion is murder, the government should not be able to force you to participate. Period. That's tyranny. That's the kind of thing they do in communist countries. Not here. I'm glad this nominee at least recognizes that the analysis should be similar to Hobby Lobby. But again, watch what they do, not just what they say. Another strong moment. Hawley asked about pro-life sidewalk counselors outside abortion clinics. The Supreme Court has said, and the nominee agreed, sidewalks are traditional public forums. Free speech rights are at their zenith. That means you can't criminalize or silence pro-lifers just because you don't like their message. The left loves to talk about democracy and the First Amendment, right up until someone uses their rights to defend unborn babies. Then suddenly, the tolerant crowd wants to shut you up. But the Constitution doesn't work that way. Content-based discrimination in a public forum is almost always unconstitutional. That's not just my opinion, that's settled law. Senator Hawley really drilled down on religious liberty. He asked, does the Free Exercise Clause deserve the same strength as free speech? The nominee said yes, absolutely. And that's critical. The First Amendment starts with religious freedom for a reason. It's the cornerstone of all our rights. The left wants to reduce religious liberty to just the right to worship in private. Sorry, that's not enough. Your faith should be protected in public life, in your business, in your work, everywhere. The nominee cited Trinity Lutheran, where the Supreme Court said you can't deny public benefits to groups just because they're religious. And he talked about Smith, which said neutral laws can burden religion. But even there, recent cases have carved out major exceptions. That's a good thing. We need judges who will protect religious liberty fiercely and consistently, not just when it's convenient. So, here's my bottom line, folks. This hearing showed why we need strong, constitutionalist judges. Senator Hawley did a fantastic job, asking tough, fair questions and defending the rights of the unborn, the faithful, and every American who wants our country run by the people, not the courts. The nominee said a lot of the right things. But as patriots, we have to stay vigilant. We've been burned before. Watch what they do. Hold them accountable. And remember, America is worth fighting for. Our Constitution is worth defending. Our children and grandchildren deserve a country where life is protected, religious liberty is cherished, and judges know their role is to interpret the law, not remake it. God bless you all. Stay strong, stay loud, and stay patriotic. Leave your thoughts in the comments. Do you trust this nominee? Will the courts finally defend our values? Let me know. Don't forget to like, subscribe, and share this video with true patriots everywhere. This is your channel name, where the Constitution still means what it says. God bless America.